All right, I want to thank everyone for attending. We have a wonderful session scheduled for you here today. Our speaker today will be Kyle Brothers. Before we get started, I have a few items of business to take care of. If I could have the next slide. Uh, our Grand Round series at Washington State University's Elson S. Floyd College of Medicine is offered in collaboration or is sponsored by the Certificate in Medical Ethics, which is offered in collaboration with Kaiser Permanente of Northern California's Regional Ethics Program. For more information about our Certificate in Medical Ethics, please follow the link here and you can find out more about our certificate and about our past grand rounds, which are available for viewing on YouTube. Next slide, please. Our next event will be March 12th, 2025, at the same time, noon to 1 o'clock Pacific Standard Time. That topic will be on paraviable infants, and we hope that most of you can attend that as well. Next slide. If you are wanting to receive CME credits for this activity has been approved for one credit in category one, uh, AMA uh, continuing medical education credits. Follow this link to fill out the forms to receive that credit. If you cannot download this link quickly enough, you can always email medicine.cme@wsu.edu. Again, that's medicine.cme@wsu.edu. Okay, next slide, please. Today, our speaker will be Kyle Brothers, who will speak to us on the topic of consent and surrogate decision making in pediatrics. Kyle is an MD and PhD, has an MD from University of Louisville and a PhD in ethics and society from Vanderbilt. He is with the Department of Pediatrics and the Institute for Bioethics, Health Policy, and Law at the University of Louisville, and he is Chief Scientific Officer for Norton Children's Research Institute and has numerous publications in leading journals in pediatrics, genetics, and in bioethics. We're very excited to have Kyle speaking to us today. And if you have questions during his presentation, I'll ask that you please hold those and enter them either into the chat function or the Q&A function at the bottom of your screen, and we will get to questions at the end of Kyle's presentation. So with that in mind, I'm going to turn things over to Kyle and allow him to share his screen and begin his presentation. Kyle?
Hello, everybody. Thanks so much for being here. Okay. It's really lovely to talk to this audience and talk about a topic that um, I use this information in my working life every single day. And this is the kind of thing that comes up frequently in clinical practice, whether you're in pediatrics or lots of other fields, obviously encounter children. So I think this will be a sort of very broad value to all of you. Yeah, and I look forward to hopefully having some time for a discussion at the end. So we're going to be talking about consent and surrogate decision making in pediatrics, and we're going to have a few cases along the way here to discuss some important topics related to this. I have a disclosure. I have a research collaboration with the genetic testing company Invitae, which recently changed to LabCorp Genetics, and I get in-kind support from them, and that's the extent of the relationship. Okay, case one. You're a primary care pediatrician in Spokane. A 17-year-old has arrived at your clinic seeking care for a sore throat. He arrives at the clinic alone with nobody else and tells the front desk that his parents aren't available because he was kicked out of the house and is living with his basketball coach. This is a true story. The staff calls his parents, the numbers on the chart, who do not answer the phone. And the patient really wants to know if he can be swabbed for strep and COVID, as there's other kids at school, including on the basketball team, who are sick. So what do you do? How do you treat this patient without an adult to give consent for their care? Okay, think about that. And let's look at case two. You're a primary care pediatrician in Yakima, and during a well child check with a 15-year-old girl, you ask the parents to leave the room. This is a very routine thing that we do with families for the confidential part of the visit. And the patient discloses she's sexually active and has worries about an STI, sexually transmitted infection. And she's agreeable to a urine pregnancy test and a gonorrhea chlamydia test using urine. And it's very important to her that her parents don't find out about this. And she asks that you keep it confidential. So how will you obtain legally effective consent for this testing with the parents not aware of it? And can you keep this care confidential from the parents? So think about that for a second. Okay, and this is really why I'm using both of these cases. What's different about these two cases? So what's different about these two cases is that there are some circumstances under which adolescents are legally empowered to consent to their own medical care. And it is important to know what those situations are. As I said, these situations do come up quite frequently. And so these are really key things to be aware of. So let's talk about what are the situations under which adolescents can consent to their own care. Okay, so you all probably are kind of mostly aware that children and adults have different legal authority in basically every jurisdiction, certainly in the United States. You sort of go through a transition from the last day of being 17 years old to the first day of being 18 years old. Legally speaking, there is a firm line. You're a minor one day, you're legally an adult the next day. However, I think everyone gets that that's not the way the development of human beings works, right? Just because the law says you're an adult on your 18th birthday does not mean that there is some major change in your ability to understand information in making decisions or to sort of exercise autonomy, independence from your parents. And that is a gradual process, right? The transition from being a child to being an adult is doesn't happen in one day. It's a spectrum. And importantly, different people go through this transition process at different times of their life, different speeds, different stages. So I'm a pediatrician. I have taken care of 12-year-olds, for example, those with cancer who have been through so much that they really are very mature and able to engage in decision making for themselves. And then I've also met 25-year-olds, who really probably shouldn't be making their own decisions. They're still, in that sort of extended adolescence period. So different people go through this process at different speeds and are ready to make decisions for themselves at different stages. And this creates a challenge for us as healthcare providers because the law says you're an adult at age 18, but we know the real world doesn't operate that way. So we have to come up with some kind of framing to allow for those folks who are minors, who are still less than 18, to be involved in decision making. That is important just so that they can be free from sort of things being done to them without their say. But also going through this sort of practicing, exercising your autonomy is an important part of growing up, right? I have a 17-year-old and we let him drive, when we're not with him. And that is part of sort of learning how to be independent. You have to practice it. Same goes for medical decision making. So, based on this kind of ill fit between the law and the real world, the law permits adolescents to consent to their medical care in three specific kinds of circumstances. I'm going to explain each of these because these are poorly understood, I would say, among many medical providers. And there's sort of distinctions between these that are difficult to sort of grasp. So I really want to go a little bit into the weeds here. So first of all, there is something called an emancipated minor. An emancipated minor is a person who is, for all legal purposes, an adult. So they have been determined through a legal process that they are able to act independently as an adult. In many states, maybe most states, this requires an explicit court order. So there's a petition that can be made to the court to say this person wants to become an emancipated minor. Then there's a legal process, usually a hearing in front of a judge, in which the state will have specified criteria and they determine if those criteria are met, and then a person can be emancipated. There are other circumstances in which emancipation is sort of becomes automatic. So, and those vary by state by state. So, I've included throughout this talk some references to what Washington does, assuming many of you will end up practicing in Washington. But just remember, these things, the details of these are going to vary from state to state. So, in many places, if you become married, in Kentucky, it doesn't matter who you're married to. In Washington, the law specifies if a minor is married to an adult. In both cases, those require parents' permission anyway. Then in Washington, if you're married to an adult, you're emancipated automatically. Also, in many places, if a person enrolls in the military, again, this often requires parental permission. If it's a minor, then they would be considered emancipated. Okay, so moving away from emancipation, let's talk about some state level statutes that give adolescents the ability to make certain kinds of healthcare decisions. I call these special consent statutes. As far as I'm aware, there's not really a standard term for these. But the key thing behind these laws is that there are certain kinds of medical care that adolescents will not receive the medical care if they can't get it confidentially. So there's a trade-off here. Uh, it is important for children to get, and in many cases adolescents, to get certain kinds of medical care. And we need to make a trade-off. We need to make it confidential for them if they are going to get it, because not creating that possibility is going to create harm. So this is sort of a compromise that gives adolescents a little bit more autonomy in areas that they are likely to not want their parents to know. Every state has these. So the standard categories that almost every state have are sexually transmitted infections, treatment for sexually transmitted infections, alcohol and other drug abuse or addiction treatment, contraception, prenatal care, pregnancy care, or childbirth care, and mental health treatment. So in the state of Washington, the ages at which this right is granted to adolescents is specified in a certain number of years: 14 for sexually transmitted infections, 13 for alcohol and drug abuse, any age for contraception, pregnancy, childbirth, etc., and 13 for mental health treatment. I know Kentucky's laws very well because we consulted about this on the ethics consultation service, and we have different ages. And just one of those things you have to learn when you move to a new state and you're going to be practicing in a new place. Okay, as you, I'm sure, are well aware, the rights of individuals to receive abortion vary greatly state by state. In Washington, minors can get an abortion without parental consent at any age, so it is sort of wrapped in with other kinds of pregnancy care. That's obviously not the case in all states. And then some states permit minors to consent to certain immunizations without an adult. And in Washington, the state law permits the homeless adolescents and those not in the physical custody of their parents or guardian to receive immunizations. Some states actually go further and let adolescents get immunizations even if they're still living with their parents, without their parents' permission. Okay, so those are specialized consent statutes. The last category is something called a mature minor. This is probably the category that is the most challenging to sort of grasp and the one that's often, challenging to understand. So a mature minor is basically an adolescent who is determined in the real world to be mature enough to operate as an adult and make decisions like one. In some states, there are statutes about what a mature minor looks like, but it's primarily a common law concept, which means that the state legislature didn't make a law about it, but there was a case that tested this, and a state court determined, yes, we're going to recognize the possibility of a minor being mature enough to make decisions for themselves. So, there are each state sometimes will have a sort of famous case or a case that really made this a thing. For Washington, it's a case called Smith versus Sibley. It's really a pretty complex case. I thought about telling you all about it, but decided that might not be a good use of time. But feel free to take a look at it at some point. Fundamentally, what this concept means is that a healthcare provider can determine in their interaction with an adolescent that they are mature by evaluating their age, their sort of intelligence, their maturity, any training they've received, sort of their life experiences. If they have economic independence, that would be a useful piece of information, and their general conduct as acting as if they are an adult and free from the control of their parents. So for the most part, this kind of like I'm a healthcare provider, I'm seeing an adolescent, and I think, oh, this person is able to make their own decisions, even though they're not 18. That's not the kind of thing that I run my clinic on, right? It is the kind of thing that is I would use as a defense in court if, for example, I made a misstep and you know a person just presented themselves as very mature and I gave them medical care, but it turned out they were an adolescent. Maybe I didn't look closely at their chart or something like that. And I could use this as a defense in court to say, yes, they were an adolescent. They didn't have legal right to consent to their care, but they seemed mature to me. So again, something you would never put into your clinic policy that if they seem mature, we're going to treat them. But you would use it as defense if something happened. So just going back to the cases for a second, interestingly, the 15-year-old female seeking STI treatment could receive that care, could consent to that care in almost every state. The 17-year-old who's not with parents, can't reach parents, and wants COVID and strep testing, actually in most states cannot get that testing unless they were to be determined to be emancipated. And they could make that case, and they would often need to go to court in order to make the case and get a court order. However, you all probably are already aware of this, but in emergency situations, you just provide the emergency care, but a COVID test wouldn't count as emergency in most cases. Okay. We're going to move on to the obligations of surrogate decision makers. So for a second, I'm going to step back from pediatrics and talk about the general obligations of surrogates, and then we'll take a deeper dive into kids. So there's a difference between a person making decisions for themselves and a person making decisions for someone else. So a competent adult is able to make decisions for themselves, even if they're bad decisions, right? So let's say, I'm 46. Let's say I have leukemia and I decline treatment for that. I'm allowed to do that. I'm a competent adult. However, when you are an adult making decisions for someone else, whether it's a loved one who is an adult but not able to make their own decisions right now, or a minor, I'm bound by my responsibility to them. So, based on that kind of idea, there are two different standards that are used to talk about the responsibilities of a surrogate in making decisions for another person. So the first standard is called the substituted judgment standard. And basically, this boils down to what would that patient have wanted in this situation? So you're supposed to use whatever evidence you have available. It might be a living will, it might be past conversations. Um, what would they have wanted? But then there are many situations in which you don't know what a person would have wanted, or situations where that person has never been a competent adult before. Like if they were a kid, then you can't use the substituted judgment standard. You have to use the best interest standard. And basically, that comes down to what's in the best interest of this patient in this situation. I will say, Laney Friedman Ross might have talked about this at your last session. Um, but this idea of a best interest standard is itself a topic of discussion about maybe it's not the, maybe best interest is not the best way to frame this, but the general idea is we don't know what they would have wanted, but the surrogate decision maker still has an obligation to do something that's good for the patient. They can't make decisions that harm that patient. Okay, yeah, so I just said this a moment ago. Substituted judgment comes down to what would the patient have wanted. It could be an advance directive. It could have been a past conversation where they talked about what they would have wanted. Or in some cases, it might be that a person adheres to a very specific sort of values framework, like a Catholicism, and maybe they really identify with their Catholic values. And in that case, you might be able to use sort of the values of that belief system to guide their decisions. And this applies when a person was formerly a competent adult and is no longer able to make their own decision. And there's maybe a question mark if an adolescent had said what they would have wanted, you might use the substituted judgment framework to make decisions for them. The best interest standard applies when the wishes of a patient in a particular situation are not known or the patient's never been a competent adult. So let's talk about a case that addresses this surrogate decision-making element. So I'm pulling this case from an NPR story that was aired many years ago now. I know this family. They were in Nashville when I was in Nashville. They were not my patients. They were sort of social friends. I'm not giving you any details that I know personally, but I'm only giving you details that's in the NPR story, and the pictures are from NPR. So just wanted to be clear about confidentiality here. So Dan and Susan, they live in Nashville, Tennessee with their three daughters, Claudia, who is an adult, and Josephine and Alice, who are minors. Dan's mother, Martha, shown here, was a breast cancer survivor. And at 63 years of age, she was diagnosed with ovarian cancer. So this pattern of breast cancer and later ovarian cancer is, a well-known sign of risk for hereditary breast and ovarian cancer syndromes. And she tested positive for a pathogenic variant in the BRCA1 gene. Not long after Martha's funeral, Dan, her daughter, or I'm sorry, his son, her son, tested positive for the same BRCA1 variant. And Claudia, an adult at the time, decided to be tested and also discovered she had inherited this variant. So then the question came up about the two younger daughters, Josephine and Alice. Susan and Claudia really wanted Josephine and Alice to get tested. And, thinking about from your perspective, if you were their pediatrician, Susan wants you to order the test for Josephine and Alice. I want them to be tested too. They're minors. She's their mom. Typically, we follow that, right? So think about, should you order this test for Josephine and Alice, who are minors? What steps would you take to decide? So one thing I hope you would do is think about what Josephine and Alice want. Um, so that's what happened in this case. And Josephine said basically, I don't know. Sure, that's okay, whatever mom wants. But Alice had a very specific reasoning that she gave. She had been inspired by her mom to breastfeed. Claudia would also consider breastfeeding to be important, and she wanted to have the chance to breastfeed as an adult someday. And she was certainly not going to get a prophylactic mastectomy before then. So she basically said, no need to know until after then. So, what legal authority do the perspectives of these two minors have in making these types of decisions? So, let's talk about the concept of right to an open future. So, fundamentally, what this concept means is that children are said to have the right over and against their parents to have certain options kept open to them until the time they become adults. So, in other words, their parents' power to make decisions for their children is limited by a right the child will have in the future to do something that they would have decided to do on their own without their parents constraining their choices. So the this concept actually comes from a Supreme Court case, and the Supreme Court case was a state suing an Amish community, saying the children in the Amish community had the right to a high school education because if they didn't go to high school, their future non-farming careers would be limited, and therefore parents were unfairly constraining their right in the future to pursue a life that was not within the Amish community. So the argument was that they have a right to an open future. For the state has an interest in protecting these young people's future ability to pursue other careers outside the Amish community. Actually, the Amish community won the case, and thereafter, young people in that state were able to stop school at eighth grade if that was the decision of their parents within the Amish community. So the question is, do children have a similar right when it comes to deciding whether or not they want genetic information until they're in adults and they can decide for themselves whether they want that information? So in this case, does Alice have the right to sort of override her mom's request for genetic testing because she wants to make that decision for herself later? I just wanted to throw this in. This is some work that I've personally done in this field. We have argued that saying that there's a right to an open future is probably the wrong way to talk about this. Because a right is something that no one can infringe upon and is sort of absolute, or it can be interpreted that way. But the way we think about this is children do have an interest in having the opportunity to make certain decisions for themselves in the future, but they have other interests as well. And so the role of parents and professionals who work with those families is to help them balance their interests. So they do have an interest to make decisions for themselves later, but there may be other things that would override that. So the question here would essentially be, are there other interests in getting a genetic test now that would override the child's interest in being able to decide for themselves later? Yeah, this is the paper where we discuss this. And the last author listed there, Ben Wilfond, he is in Seattle, one of your neighbors. So our idea of open future interests is essentially children have lots of different interests. Parents have to help weigh those interests until the kids are adults. And there could be other interests that outweigh the child's interest in keeping certain decisions open. So just something to think about. The reason I bring up this right to an open future or interest in an open future is that national organizations, the American Academy of Pediatrics, have for decades recommended against genetic testing for children for these conditions like hereditary breast and ovarian cancer, that you wouldn't actually do anything until the young person is an adult. So basically, there's no medical reason to do the testing on a minor, so they should therefore be able to wait until they're an adult to decide. Um, but when we think about this, you can imagine situations where the parents might want to test a child mainly because the parents actually would benefit from that information, or maybe a sibling would benefit from that information. So, yeah, I mean, just in general, these kinds of decisions should account for the best interest of the child. It's okay to consider other kinds of interests with the family, but you should always focus decisions about a child on the interests of the child, not somebody else's interests. And you should always account for the preferences of the adolescent, even though they're not legally authorized to decide. And yeah, this is something that maybe Lainey talked about, Tom. But there's a really interesting question here about how to bring in the adolescents' rights, ability to be involved in decision making against the parents. A really interesting topic, and difficult kinds of cases come up in that space. Okay, that's it for right to an open future. So now let's go to case 4. Again, these are all real cases. So I just want to talk for a minute about capacity versus competence. So capacity refers to a particular decision. So it's the ability of a particular patient to make a particular decision at a particular point in time. So you all likely know when folks are in ICUs or they're in other forms of medical care, their alertness can change from hour to hour. There are some situations in which a person might be able to make certain kinds of medical decisions that are relatively straightforward, but maybe really complex ones, they just are not in a space that they're able to make those decisions. So capacity really refers to this sort of changing ability of people to make decisions, and that can change quickly. And it's really up to the attending physician to assess a person and figure out, are they making a decision that they're able to make right now? And there's all sorts of great work teaching attending physicians how to do this, but fundamentally you're asking the patient to tell me what I just told you. What do you understand about this decision? What are the pros and cons, et cetera? Basically talking through it in order to evaluate whether the patient right in this moment is in a situation where they can make the decision. Competence is a different concept. Competence really refers to a permanent or basically long-term status of a person who may or may not be able to make any decisions for themselves. So by default, all adults are assumed to be competent. So when you turn 18, boom, the assumption legally is that you're competent. But through a court action, a person can be determined to be permanently incompetent to make decisions. And that can apply to all decisions. So if you are determined by a court to be incompetent for all kinds of decisions, that would mean that you don't manage your finances anymore. You don't manage your health decisions anymore. Or it could be just certain kinds of decisions. It might just be that you're not competent to manage your finances, but you would be able to make your healthcare decisions. So yeah, I hate to bring up public press kinds of things, but like Britney Spears was this kind of situation where she was determined not to be competent to manage her own finances, and I assume she was able to make other decisions during that time. Okay, so here's the case. 19-year-old patient with a congenital heart defect and also has intellectual disability resulting from early, health challenges. So there was a valve replacement earlier in childhood, and the child now had a dysrhythmia. And he needed a pacemaker to be placed relatively urgently within 1 to 2 weeks. It wasn't an emergent thing, but ideally you would do it before it became an emergency because then the risks would be much higher. As a child, this young man lived in a foster home and group homes, and those people at those facilities had been assigned by the state to make decisions for the child. But those places did not keep adults, did not care for adults. And so once this young man turned 18, he actually got moved to a group home for adults. And that's where he lives now. He's really a neat young man. He's able to interact and talk with you about things, really enjoys life, but clearly doesn't have the capacity to consent to surgery because he can't understand the risks and benefits. And I talked with him as an ethics consultant and asked him questions. He really could not engage with what are the risks of this surgery, what are the benefits of this surgery, et cetera. So the ethics consult that we had was basically who can consent for this surgery because the patient had not been found incompetent. And as I said, all adults are assumed legally to be competent until something changes, but until a court determines they are not. The normal practice of this group home is to obtain guardianship so that the people there who care for that person can help make their healthcare decisions. But this takes time, and it had not yet been done for this young man. So the question that came up is it possible to get consent for this surgery before it becomes emergent? And so this patient was in Tennessee. This is when I was in Nashville at Vanderbilt. And in this case, the patient's primary cardiologist was able to provide consent because of the way the state law is structured there. So I thought we could look at Washington's law and explore that here. So this is a very standard kind of thing. Every state has this kind of law. It basically specifies the order of preference for choosing a surrogate decision maker in a situation where a person is unable to make their decisions, either because they temporarily don't have capacity or if they are incompetent, but a official decision maker has not been appointed yet. So yeah, I mean, this is the order. An appointed guardian of the patient, if any, is always the decision maker. 2, a person might have assigned durable power of attorney to another person. If there's neither of those, it could be a spouse or a state registered domestic partner that's permitted in Washington. And then, going down the list, children of the patient, parents of the patient, adult brothers and sisters of the patient, adult grandchildren of the patient. Many states don't have this. This is really a strength of your law in Washington. Adult nieces and nephews of the patient, adult aunts and uncles of the patient. And then finally, you have this 10th category where a person can make decisions for another person if they are an adult who has exhibited special care and concern for the patient. This is actually in the Tennessee law as well, and this is why the cardiologist was able to make this decision for the patient because she had cared for him for more than a decade. That person in Washington has to be familiar with the patient's personal values, is reasonably available to make healthcare decisions, and the Washington law states it cannot be a physician to the patient or an employee of the physician, and then goes on to specify owner, administrative employee of a healthcare facility, et cetera. So yeah, this is a key issue that does come up, especially for like 18-year-olds, 19-year-olds. And the key thing to remember is anytime you have a person who has an intellectual disability is basically not able to make their healthcare decisions and never will be, you really need to kind of be alert that when they turn 18, you really need to start a legal process to address guardianship because these folks will need someone to make decisions for them, ideally before it's an emergency. Okay, that's actually all the lecture part of this that I have. I'm going to unshare And I'd love to, yeah, talk about questions. Yeah, anything that you all want to talk about.
Kyle, we have one question on the Q&A. I'm going to reframe it slightly for our audience. I'll explain that I never like to ask our speakers to comment on a specific case because you don't have primary access to the actual information of the case. So, I
Yeah,
don't want to ask you to make a recommendation on a particular case that you don't have. You're being presented the information secondhand, right?
yeah,
So I'm going to reframe it somewhat more generally, although very similarly, to ask you to imagine a 17-year-old who presents at a clinic for chemotherapy treatment and presents without a parent present, right? The the parent had previously expressed that she did not want this 17-year-old to receive chemotherapy. But the patient, the 17-year-old, is adamant that they do wish to receive this chemotherapy. How would you generally, in general, not on a specific case, but in general, how would you approach, resolving this or
yeah.
addressing it?
This is a really great question. So, I mean, generally speaking, depends on exactly how the hospital handles this kind of thing. You could call either an ethics consult, or many hospitals have like a risk management office or hospital general counsel. And because the situation here is basically the parent is making a decision that is likely to harm the child. That's my interpretation, assuming that this chemo is actually obviously going to be helpful. Because you can actually not treat that young person, there's no legal authority to do so. So if you were to treat them, you will have committed battery, like unconsented touching. And you really don't want to do that, right? Because you'll lose your medical license. You could be arrested. You could be sued. Um, it's not a good idea. So what you do is you want to work with your hospital's lawyers to figure out, how do we get this young person the medical care they need? And will happen is the hospital's lawyers will petition the court to compel the treatment. And that would likely in many places involve CPS, Child Protective Services, to sort of assess that risk. But in many cases, there's states and judges vary about what their willingness to sort of override parents. In many cases, the parents' decisions hold a lot of authority, and courts are very hesitant to override them. But especially when you have a very old adolescent, nearly 18, if they disagree with their parent, courts will often take their they will take the adolescent's decision as sort of really strongly having a meaning. So I think in this case, you'd go to court, ask the judge to order the treatment. They would likely do that, and then you would do the chemo. Um, and yeah, it would delay it probably at least a week, but that's the way to get it done.
Just to let you know, Gerald Schatz, a professional bioethicist who's attending today, says that in DC, the Superior Court has a judge in chambers who's always on call for such emergencies.
Yeah,
So that's something to keep in mind
great.
there. Uh,
Yeah.
We have a couple of questions asking if you would be willing to discuss the concept of assent for treatment among minors and how that relates to age and how assent relates to consent.
Yeah. This is another one of those situations where the real world is a spectrum, right? The ability of adolescents to participate in decisions is a constantly changing thing from birth to 18 years of age. Um, but then there are sort of like rules of thumb that are used to guide decisions. So there's something in ethics called the rule of sevens. And the rule of sevens basically means from 0 years of age up to 7 years of age, typically children are not able to engage in meaningful decision making. They mainly need to be informed about what's going to happen. So, we're going to do a needle stick. It's going to hurt for a second, but that's it. So then from 7 to 14 is the period in which you would sort of have a more formal decision-making conversation with the parents, and then you'd separately have a sort of providing developmentally appropriate information to the young person about this is what we're deciding about. Are we going to do chemotherapy? This is sort of likely to happen. These are the risks and benefits, but in a very age-appropriate way, not doing all the details. And then from about 14 up, we would generally say in making sort of clinical decisions, the parents and the adolescent are present together, and you're giving the adolescent all the information. Um, Again, in all of these situations, the adolescent's ability to make a decision doesn't hold legal authority, but they have a right for their interests to be heard. And so that is a very serious right from 14 to 18. And so you really would engage them in a very meaningful way in the decision. Um, so that's what we call assent. The listening to what an adolescent has to say about their own care, even though it's not legal authority. Let me just say one more thing about that. Um, I gave you the rule of sevens related to assent, but there's sort of a secondary issue about providing medical care to young people against their will, which is basically, can you do it safely? So you might have a 6-year-old who, according to the rule I just told you, really has no right to engage in medical decision making, but they absolutely don't want you to put in that IV, right? Or they don't want to sit still for you to do an LP or something like that, a lumbar puncture. So that is sort of a secondary issue, separate from sort of the ethics of including people in the decision about can we do something in a way that is safe if the person's not on board. So there are ways to approach these decisions with children that is really talking them through it, trying to address their concerns, trying to help them understand what's going to happen, primarily to keep them safe. So this can be quite complex. In some situations, you might actually not do something, even if the parents want you to, simply because you can't effect that safely for the child. Tom, do you think that covered it, or?
I think so. Yes,
Okay.
thank you. I have my own question for you, Kyle. Take you back a few years, if you don't mind.
Uh-huh.
You'll remember that the American College of Medical Genetics and Genomics issued some recommendations to sort of, without consent, look for certain secondary findings for
Yep.
everyone who receives genetic testing for any reason. And those original recommendations offered a justification of looking for certain of these, what we call dispositional variants that you rightly pointed out. ACMG, in other circumstances, recommends against testing on children, but justified looking at those here because of the need for the information and its relevance for of these findings for parents' potential need to get tested.
Yeah.
Right. And that was one of their primary justifications of doing this for children without consent. Do you think this type of justification is convincing, or does it potentially place the interests of family members above the potential interest of the child? And I wondered how you thought about that.
Yeah. You may have picked up, I was kind of hinting at some of these issues.
Yes.
So basically, the argument is we're doing genetic testing on the child. Maybe we're doing a whole exome or a whole genome on the child because maybe they have developmental delay or something. We're trying to diagnose a condition. Has nothing to do with breast and ovarian cancer. But, by the nature of the test, we actually could go looking in their genetic data to figure out, do they have a BRCA1 variant? And again, not relevant to the child right now because it wouldn't be a thing that you would worry about until they're 20, maybe 30 years of age. But if we found it in the kid, that would be helpful because then the mom or dad could find out through that they actually passed it on to their child. And therefore, it could be relevant, for example, if their mom would want to have a prophylactic mastectomy, have the breast removed to prevent breast cancer because mom didn't know that she harbored this variant that she happened to have passed on to her child. Um, so it's a great question. What do I think? Um, a couple of distinctions. One, it's a little bit different when you're deciding whether or not to test a person than it is to decide whether or not you disclose something you already found out. So sometimes genetics laboratories, they will um, not do a good job of hiding things they don't want to know, and they will find things out even if the patient didn't want to know them. And so, in general, my view is if you find something out, we say incidentally, you didn't mean to, but you can't not find it out, you need to disclose that. So you shouldn't know something about someone that's relevant to their health without telling them. However, I think it's a very different kind of question about, yes, there is some that like really complex terabytes of data from a person's genetic test. Am I going to go looking for this test, for this result, specifically so I can help the parent? And I think that is a very um, wrong-headed way of approaching the care of children. Um, I'm not saying it would never be an okay thing to do, but it's not the kind of thing you would do by default. Because if you just routinely do things to kids because it's going to help out their parents, then that is ethically questionable, right, and risky. So my personal view is it could be totally reasonable to go looking for that, but it really requires some thinking about what's in the interest of the child, what are the family's interests, to what extent are they different, and just being careful about how you proceed. Many people argue correctly that if you save a parent's life, that's good for the kid. Um, and I mean, I can't argue with that. That's obviously correct. Um, but I do think that it requires some really thoughtful care and attention. Um, I in this paper that I showed that Ben Wilfond and some others worked on, we actually talk about a few situations where we think it would be totally reasonable to test a minor for an adult onset condition. So, for example, if you've got a 16-year-old who's planning to go to college and they want to know before they head off to college and choose their career, am I going to develop Huntington's disease? Like, is that relevant information to my planning my life? Then you could see that there could be an interest in getting testing that outweighs the sort of like waiting till they're an adult and can make decisions themselves. So anyway, I don't think it's a situation where you can never do this in minors, but it's something that requires, yeah, just careful attention.
Heather Brackett, you had a question?
I didn't. I didn't actually. I'm so sorry. I don't know how that happened.
Okay, your hand was raised. Okay, with that, I think we're actually right about at our time, and I wanted to thank Dr. Brothers for a wonderful talk. And I want to remind everyone that if you look in your chat, there is a link there for CME credits, as well as the email. Once again, if you have questions about CME credits, medicine.cme@wsu.edu. And I hope to see all of you at our next Bioethics Grand Rounds. And the session today will be posted on YouTube, probably within a week. There's no guarantees, but it'll probably be within a week. So thank you all for attending. And Dr. Brothers, thank you once again for your wonderful presentation.
Thank you so much for having me. It's great to see you all.